All rise, vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Court officer, can you please call the case?
Good morning, Madam President. Situation in the Republic of Mali in the case of the prosecutor versus Hassan Abdul Aziz Ahmed Mahmoud, case reference ICC 0112-0118, and for the record, we are in open session.
Thank you. Can those present please introduce themselves for the record, starting with the prosecution?
Mr. Duterte.
Bonjour Madame la Présidente.
Good morning, Your Honor.
Je permets de présenter Diane
I'd
Looping à ma
like
gauche,
to introduce Diane Looping to my left,
Esham Mourad à ma droite.
Esham Murad to my right.
Derrière moi, vous avez
Behind me, you will see
Elena
Elena Martinsa Sagado,
Marie-Jeanne Sardachti
Marie-Jeanne Saldacci,
et Nelly Corbin.
and Nelly Corbin.
Et au dernier rang,
And in the
Moussa
final
Alafi,
row, we have Moussa Alafi,
Yaya Yamaguchi
Yaya Magoruchi,
et Florie Huc.
and Flori Huc,
Et moi-même, Gilles Duterte.
and
Je vous remercie.
myself, Gilles Duterte. Thank you.
Merci beaucoup.
The presiding judge, thank you very much. Defense.
Good morning, Your Honour, and good morning to my colleagues in the courtroom. My name is Melinda Taylor. I'm appearing on behalf of Mr. Alassane today with, on my right, Miss Madame Marilyn Prue, Miss Sarah Baffadel, Mr. Guillaume Suzuki, Mr. Mohammed Youssef, Miss Sarah Marinier Douce, Miss Dolly Challa, and Mr. Alassane is himself appearing today. Thank you very much.
Ms. Taylor, I now turn to the representatives for the victims. Please.
LRV. Microphone. Mayombo.
Il y a mon confrère Mayombo Kassongo.
Mayongo Kasongo.
Derrière,
And behind me,
à gauche,
to the left,
Madame
Madame
Claire
Claire
Place
Laplace
et Madame
and Madame
Prisque
Prisque
Bieke.
Bieke.
Je vous remercie.
Thank you.
Merci beaucoup.
Judge Prost, thank you very
And
much.
The registry, Mr. Dubuisson.
Je vous remercie,
Mr.
Madame la
Dubuisson,
Présidente.
thank you, Madam
Sur le banc du greffe avec moi, il y a
President. With me
Marie
today,
Mathieu, juriste
we
pour
have
les
Marie
affaires
Mathieu, legal
Jamila
officer,
Zoubir,
Jamila
juriste
Jousbi,
coordinatrice,
legal officer
Esteban
and coordinator,
Peralta, qui est
and
le chef de la
Esteban
section
Peralta,
d'appui au
Chief
Conseil, et
Counsel
moi-même,
Support Section,
Marc
and
Dubuisson, le
as for
directeur des
myself,
services
Marc
judiciaires
Dubuisson,
pour le
Director,
greffier Peter Lewis.
Division of Judicial
Je vous remercie.
Services, appearing on behalf of the Registrar Peter Lewis. Judge
So
Prost,
today's
thank you very
status
much.
Conference is held to discuss the matters listed on the agenda of 13th February. That is filing number 587. I would like to hear from the prosecution, the defense, and the LRVs, and of course the registry as necessary, as appropriate on the various questions, and I will also have some questions to raise. We're going to sit for 2 sessions if needed. We expect we will need it. The first one running till 11 o'clock and the second from 11:30 till 1 p.m. In principle, I would like the status conference to be held in public. Obviously, the parties and the participants, however, should advise if there is a need at any time to go into private session. But I do express my wish that we remain in public session as much as possible. And we'll run through the agenda in chronological order. So I would like to begin with the first item, which is the update on the prosecution request to amend the charges. And I would like to hear from the prosecution on that matter. Mr. Duterte.
Merci, Madame la Présidente.
Mr. Duterte, thank you, Your Honor.
Sur la question
Now,
de,
on
la
the
requête
issue of the
au fin d'amendement.
application for changes,
L'accusation,
amendments
comme
to
vous
the
avez pu voir, a
charges.
déposé sa requête
Now, we did make our filing
aux fins d'amendement et de correction
with
de
a
la
view
décision de
to
confirmation des charges
corrections and changes to the DCC
le 31
on
janvier
the
2020.
31st of January 2020.
C'était le filing
And
568.
that was filing 158.
568.
568, correction from the booth.
Cette requête était assortie de 4
This
annexes
application had 4 annexes
et ces annexes contenaient
and
les
the
éléments de preuve au
annexes
soutien de la requête.
contained the evidence supporting the application,
Cela comportait notamment les
and in
déclarations des 4
particular,
témoins
statements from 4 witnesses,
P524,
P154,
P636,
P606,
636, 636,
636,
P0639
0639,
et P0641.
and P641.
Le 5 février
On the
2020,
5th of February 2020,
la défense a déposé
the
une requête pour
defense
clarifier
made
la
an
question
application requesting
des
clarifications
délais applicables pour répondre à la requête de l'accusation.
concerning this matter,
Et la défense
and
sollicitait
the defense
notamment deux
asked
choses,
for 2 things in particular.
que la chambre préliminaire
That
1
Pretrial Chamber 1
fasse partir le délai pour répondre à la requête
push back the deadline
au moment du dépôt de l'évasion en langue
At the
arabe de la requête de
time
l'accusation,
at the time of the filing
de la version en
in
langue arabe
of the Arabic version
de la requête de l'accusation.
of the OTP filing,
Et la défense sollicitait
and the defense
également
also asked
la suspension de tout délai pour
for
répondre
suspension of any
à la requête de
deadline
l'accusation.
with a view to responding to the said application.
Subséquemment, le 7 février
Subsequently,
2020,
on the
Madame la
7th of
Présidente,
February, Madam President,
la chambre préliminaire
the
1
Pretrial Chamber 1
a fait droit à la requête de la défense
granted the
fin de suspension
application
des délais.
from the defense for suspension of the deadline,
et la chambre préliminaire a
and the
précisé
Pretrial Chamber specified
qu'elle fixerait les délais
that
pour les réponses de la
they
défense et des
would set a
représentants légaux
deadline for responses from the LRVs
à la requête
and the
présentée
defense
par le procureur
in response to this application from the prosecutor
dans une décision qui serait rendue
in
ultérieurement.
a later decision.
Le 14 février
On the
2020,
14th
l'accusation
of
a déposé
January
elle-même des
2020,
observations concernant la requête de la
the
défense du 5 février
proposition
2020
filed a number of observations,
et l'accusation s'est prononcée sur
and
le point de
the
départ du délai pour
prosecution
répondre
made
et
some
sur la
points
durée du délai pour
regarding
répondre.
the commencement date and the various associated deadlines.
Hier,
Yesterday,
le 17 février
on the
2020,
17th
Madame
of February
le juge,
2020,
les services du greffe ont normalement
the
déposé la
registry
traduction
services were expected
en arabe
to
de la
file
requête de
an
l'accusation
Arabic
aux fins d'amendement et de
translation
correction de la décision de
of
confirmation des charges.
the application in question. Message from the interpreters. Prosecution is reading from a prepared text which the interpreter does not have.
Je répète donc, les services du greffe ont normalement
The
déposé la
registry
traduction de la requête de
services
l'accusation
were expected to
aux fins d'amendement
file
et de correction de la décision de confirmation des charges.
this document.
Les services du greffe avaient
The registry
très aimablement
services
accepté de
very
se charger de
kindly
ce travail,
agreed to take on this work,
mais je n'ai pas encore vu la
but I have
notification,
not seen any notification.
mais cela devrait se
But
venir aujourd'hui.
I'm sure it will be on its way and we should be receiving it today.
Toujours hier, le 17
Now,
février,
yesterday, on the 17th of February,
l'accusation a
the
communiqué
prosecution disclosed
le paquet pré-confirmation
a
in crime
pre-confirmation
numéro 52,
in crime package 52
contenant les traductions
containing
expurgées en arabe, des
the
déclarations
redacted
écrites
translations in Arabic
des 4 témoins
of statements taken from 4
dont j'ai mentionné les
witnesses.
P-numbers
and
précédemment.
I provided those witness numbers earlier.
Donc P0524, P0636, P0639 et P0641. C'est pas traduit.
P524, P639, and P641,
Et P636.
and P636.
Également hier,
Furthermore, yesterday,
l'accusation a déposé la
the
version
prosecution
publique
filed a public
expurgée
redacted version
requête
of its application
aux fins d'amendement
with
et
a
de
view
correction de la
to
décision de
amendments and
confirmation de
corrections of the DCC
tel que cela avait été sollicité
as
par
requested
la Chambre préliminaire 1.
by Pretrial Chamber 1.
En conclusion,
Now, to conclude,
c'est maintenant dans
it
les
is
mains de la
now
Chambre
in the
préliminaire 1,
hands
Madame
of
la juge,
Pretrial Chamber 1, Your Honor.
que les statements ont
The
été
statements
communiqués en
were
langue
disclosed
arabe.
in Arabic.
La traduction de la requête de
The
l'accusation
translation of
ne
the
devrait pas tarder.
prosecution application should be coming soon, and perhaps Mr. Dubuisson will be in a position to confirm.
Et donc maintenant,
thus,
la Chambre est en position de
Now,
pouvoir fixer les délais pour
the
répondre.
Chamber is in a position to set a number of deadlines for responses.
Et nous avions
And
souligné dans notre requête
we
la
stressed in our
nécessité
application that it was necessary
de processer rapidement
to
compte tenu
proceed
du
rapidly
début,
because
du procès que
of
vous avez
the
fixé au 14 juillet.
upcoming commencement of trial, 14th of July of this year.
Voilà les quelques éléments que je souhaitais
So,
indiquer.
this is the information that I wanted to provide to the Chamber.
Merci.
Judge Prost, thank you very much. And before I ask for the
Monsieur Dubuisson,
defense to respond, Mr. Dubuisson,
could you advise us if you have any indication on the status of the translation?
Non, à l'instant même, je ne peux malheureusement pas vous
right
répondre,
now
mais
I'm
je
not
suis
in a
occupé à
position
essayer
to
d'écouter
respond,
l'information.
but I am gathering that
Thank you.
information.
And if you have any information to provide, if you can just indicate and we'll give you the floor. Thank you. Ms. Taylor. Oh, sorry.
Merci, Madame la Présidente.
Ms. Plouffe, thank you, Your Honor.
À ce stade,
At this particular stage of the proceedings, and since the request for amendments to the charges is before the pre-trial chamber, we'll just make a few preliminary observations. First of all, this was filed rather late in the proceedings, between 4 to 6 months after the gathering of statements from these new witnesses, and after the chamber set the commencement date for the 14th of July. Now, furthermore, the application was filed without an Arabic version of the application or the statements being provided to the defense. The documents were just received yesterday. Now, we did receive the translation into Arabic of the prosecution's application, but it was more than 2 weeks after the application had been filed. So, given that context, it would not be suitable to put the blame of the delay upon the shoulders of the defense, because the application for amendments to the charge is not some minor filing. Secondly, the defense is entitled to benefit from not only relevant material in the Arabic language, but also from the necessary time to consult Mr. Hassan and to prepare a detailed response concerning the fresh allegations from the OTP. I would like to focus on one point raised by Mr. Duterte. We did not ask for an additional extension, as he said in his filing, but rather we asked for clarifications and we asked for the fundamental rights of Mr. Hassan to be respected. Furthermore, the situation is entirely in the hands of the pretrial chamber. And at this point, the pretrial chamber has not made any particular decision in this regard. The defense wishes to stress that even though the pretrial chamber has been seized of the application, it would not be a good idea for your chamber and that chamber to be seized of similar matters at the same time, because only the trial chamber is in a position to make decisions on the proceedings underway. The defense approached the OTP to understand whether the pretrial chamber was also seized of these matters at the same time, but we did not receive any clear response to our queries. To conclude, the defense has already said and reiterates today that under no conditions do we want to see the trial delayed. We do not want to see any changes to the deadline, the commencement date set by the single judge. Mr. Hassan has been in detention for more than 3 years. The defense wishes to advance its arguments before the pretrial chamber and shall await the decision there from that chamber. Thank you.
Merci, Counsel.
Judge Prost, thank you.
I believe the positions on this matter are now noted on the record. I would note that this is a matter before the pretrial chamber, so this was an information item. We now have, I think, the information necessary for the trial chamber to be aware of. So I would suggest that that's sufficient for this agenda item unless anyone feels a strong need to provide any additional comments. I don't see anyone motioning accordingly, so let's move to the next item on the agenda, which is the status of ex parte filings on the pretrial record. Now, this was a matter which was placed on the agenda by the defense, indicating there are 30 such ex parte documents. And so I'd like to hear from the defense on this particular item. Ms. Taylor.
Thank you very much, Your Honour. This issue can be dealt with quite shortly. We've identified, just from missing numbers, that there does appear to be a substantial number of ex parte filings. We communicated the number to the prosecution yesterday. We estimated 25. They have communicated that they believe that 3 of them are ours, although we can't access those 3, but it is entirely possible there was former counsel or the registry. But even if we're dealing with a number of 22, that's still a significant amount of litigation that remains hidden from the defense. And we believe that even if it was necessary and proportionate at the pre-confirmation phase, the rationale should be reviewed in light of the advanced stage of the proceedings. And we would like to highlight the potential for prejudice, in particular as concerns an application which we have mentioned through disclosure correspondence and before the single judge, as concerns Mr. Hassan's interviews and the extent to which those interviews may have been cited in ex parte filings to justify certain measures that were taken at the pre-confirmation phase. So we have a very specific and immediate need to go through this litigation so that we can prepare an application that's pending. So we would ask that the prosecutor be ordered to review all ex parte filings in the record in order to prepare lesser redacted versions as and where possible. Thank you very much.
Thank you. Can I hear from the prosecution on this issue?
Oui, Madame la juge.
Mr. Duterte, yes, Your Honor.
Yesterday,
18h40, at about 6:40, we did receive an email from the defense listing
plusieurs filings,
several filings,
enfin plus d'une quinzaine,
more than 15,
sur
having to do with all these various
il
filings.
n'y a que
And
5
only five
écritures qui proviennent de
filings
l'accusation
are from the prosecution,
pour laquelle la défense n'a pas
for
accès.
which the defense does not have access.
Il y en avait une sixième qui était
There was
listée,
a
mais en fait,
sixth
ils ont
one on the
accès
list, but in actual fact, they
à
do
une
have
version
access to one version of that
qui doit être
particular filing, which had to be redacted.
Donc, d'une part,
So,
nous
on the
allons
one hand,
revoir ces
we will
filings
review these
aux fins
filings
de proposer quand c'est
so
possible
as to suggest when it is possible
et de déposer une version confidentielle expurgée.
To file a confidential redacted version.
Pour le reste, ce sont
As for the rest,
des écritures qui ne viennent pas de
these are
l'accusation.
filings that do not come from the prosecution.
Mais du coup,
But
cela m'amène aussi à
this
évoquer un point.
does lead me to raise a particular point.
Il y a aussi des,
There are also
des écritures ex parte de la
ex
défense
parte defense filings
pour lesquelles des
for
versions
which
confidentielles expurgées auxquelles on pourrait avoir
redacted
accès
confidential versions
s'imposent
are
tout aussi bien.
needed as well.
Et donc, je pense qu'il
Thus,
appartient à
I
toutes les
think it's
parties
really up to all the parties
de revoir leurs écritures et
to
de faire
review
de
their
telles versions
filings and
confidentielles
to
expurgées.
provide such confidential redacted versions.
Je vous remercie, Madame la
Thank you, Your Honor.
Thank you very much. I think we can probably shortcut this issue because I do agree with the last point of the prosecution. In fact, there are, from our own examination of the matter, there are filings which are ex parte registry only as well involved in this situation. And so I think what might be the best way forward is to ask the registry or instruct the registry to put on the record by the 26th of February a list of the real ex parte filings, meaning any filings for which no version is available to either prosecution or defense, in some instances both. And these should then all be reviewed by the relevant parties, be it the defense or the prosecution or registry, with a view to providing redacted versions to the other party or perhaps seeking reclassification. So I think that by that way, we can proceed to deal with all of the material that's been raised in a manner I think that should be acceptable to all parties. And I would ask that this process be concluded by the 18th of March at the latest. But I appreciate the point of the defense that this is a matter in terms of preparation. So as soon as possible, if those two dates could be adhered to, that would be very helpful. So I think that I see Mr. Dubisson nodding in agreement, so I trust that that is an acceptable way forward for everyone. Thank you very much. Now, if we could proceed to the issue of the impact of the Al-Mahi reparations proceedings. And again, I believe this was a matter which was raised by the defense. So I would like to hear from the defense team on this particular point.
Thank you very much, Your Honour. This is something that has come to our attention through the review of a public redacted implementation plan that was filed by the Trust Fund for Victims in the Al-Mahdi case. Now, we're not a party to the proceedings in the Al-Mahdi case. We don't have standing in that case. But having reviewed some of the public redacted filings in that case, we consider that there may be issues arising from the reparations phase that could impact upon this case. So we wanted to raise them at this juncture of the proceedings so that they could be factored into any disclosure protocols or contact protocols that might be adopted by the Chamber. And there are three possible issues where we see that there could be some form of impact. The first being the contact protocol, the second being disclosure issues as concerns application forms. And the third concerns possible contamination of evidence, in this case from some of the projects that have been listed in the implementation plan. Now, the first point, and this might be not necessarily ripe to bring before the Chamber, but we have seen from some of the filings in the case that the Trust Fund, as is entirely within its mandate, is liaising with a range of community leaders and individuals in Bamako and Timbuktu in connection with the implementation of its plan. And we wanted to highlight the fact that this could have an impact on witness protection or witness issues if any of the persons who have been identified by the Trust Fund for this purpose are potential defence witnesses or indeed prosecution witnesses. So we intend from our end to liaise with VPRS, VWU and the Trust Fund to identify how we can best regulate this. Since we don't have much information on it, it might be premature, as I mentioned, to actually factor it into any contact protocol. But we did want to raise it, as it is already apparent to us that it is an issue. The second matter concerns the disclosure of applications for reparations that were submitted in the Almaty case. Now, as I mentioned, we're not a party to that case, so we don't receive that documentation. There is, however, a clear linkage between the cases in terms of the crime base as concerns the destruction of cultural property. And we can see various instances where information in those application forms could be relevant to this case. For example, if an application for reparations is rejected in the Almaty case, and that person is a witness in this case, then the fact of that rejection might be relevant depending on the reasons for rejection. For example, if they were rejected in connection with the details that they gave concerning the destruction of cultural property or due to problems with identification documents. It might be relevant as well if they're applying for reparations in this case, again, depending on whether they're applying for exactly the same reason for which they were rejected in the other case. It's also possible the prosecution witnesses might have applied for reparations and received individual reparations in the Almaty case, but not applied for them in this case. So even though they are effectively dual status, we wouldn't know of the dual status. And we would submit for, again, this goes to the modalities of participation, which haven't been resolved yet, but depending on those modalities, for actively participating victims, those who might testify in person, we would consider it relevant to receive a copy of any reparations forms submitted in the Almaty case and information as to whether they received reparations in that case. Now, we understand that the prosecution is somewhat in the same boat as us, as they are not a party to the reparations proceedings, but there might be a simple procedure that could be implemented. For example, for prosecution witnesses, perhaps the prosecution could liaise with VPRS, who could identify whether these witnesses have been granted the right to participate or granted any form of reparations in the Almaty case. And if that were to be the case, then in the same way that we've proposed that unredacted applications go to the prosecution in this case, we would submit that the prosecution should also receive the unredacted applications from the Almaty case. Now, in terms of the third point, which is an issue of possible contamination, we've identified from the publicly redacted version of the Trust Fund plan that one of the proposed projects was to create a safe space for women to come together and speak about the Almaty crimes and forms of discrimination that related to those crimes. And that this would be conducted under the auspices of a particular psychologist And it would seem that from some of the filings, a particular NGO whose identity was redacted might be involved. Since we're not a party, we don't know the specific details of this proposed plan. Now, of course, this is a very admirable plan, but if these groups are to involve witnesses in this case, if the project is to involve NGOs who might be actively participating through some of the witnesses or the victims who have applied to participate in this case, then that may raise issues. Now, this chamber doesn't have standing over the reparations phase in the other case, but it does have the power to take such steps as are necessary to protect Mr. Al-Hassan's rights. So at this point in time, we will endeavour to find out as much information about this project, in particular as to whether it's already started or whether it can possibly be deferred for the duration of this trial. And then when we have that information, we wanted to signal to the chamber that we may need to come to the chamber to seek appropriate measures, whether it be disclosure or other forms of remedies. Thank you very much.
Thank you very much, Ms. Taylor. The chamber certainly appreciates you bringing the issue onto the record at this stage, so that the chamber is aware of the potential issues. Does the prosecution have any comments on this particular issue?
En général, sur les questions
Generally, with regards to the issue
développées par Madame Taylor, oui, Madame la juge.
explained by Madame Taylor, yes, Your Honour.
Je voudrais simplement commencer par
I would
dire
just like
que,
to start by saying,
comme, et je vais citer la Chambre 8,
and I'm going to quote the Chamber 8 on this point,
dans son ordre
in its order
0112-0115-172,
0112-172,
à la note de page 3,
footnote 3,
la Chambre de
the
première
chamber,
instance 8 a indiqué
the Pretrial Chamber stated
que les parties
that
pour
the parties
les questions de
for the
réparation
question of reparations
sont entendues comme étant la
are
défense
understood as being
et
the
les
defence
représentants
and
légaux des
the
victimes.
legal representatives of victims.
Et donc, l'accusation
As
n'est
such,
pas
the
effectivement,
prosecution
partie à ce
is
processus
not
de
a
réparation.
party to this reparations process.
Plusieurs points qui sont soulevés
Several
par
points have been raised
la défense
by the defence,
concernant
and
effectivement
particularly concerning
des témoins de l'accusation
prosecution witnesses
qui pourraient être concernés par
which could be
ces questions de
concerned
réparation.
by the reparations issue.
Alors je me réfère à nouveau à
Now,
la
I would
Chambre
like to
de première
refer
instance
to the
8,
Pretrial Chamber 8 once again,
et je cite
and here I quote,
according, enfin, la Chambre 8 indique que
Chamber 8 indicates
les
that
personnes individuelles
individuals
qui sont légitimes à demander
who
réparation
are legitimately asking for reparations
sont limitées,
are limited
et je cite, à ceux
limited to those
whose livelihoods exclusively dependent on protected buildings. Et aussi
and also
à ceux
to
whose
those
ancestors' burial sites were damaged in the attack. Donc, parmi
so as such,
les témoins de l'accusation,
among the prosecution witnesses,
comme ça, à chaud, à première vue,
at first sight,
il est peu probable qu'on ait des
it is
individus qui tombent
hardly
dans ces
probable
catégories.
there are individuals that would fall within this category.
Alors, effectivement, on a des témoins qui
Now,
ont
indeed, we do
témoigné
have
en salle
witnesses who
d'audience,
did testify
dans l'affaire Almadi, mais
in the
c'était
Almadi
des témoins
case,
experts
but those were
qui ne tombent
expert
pas dans cette
witnesses
catégorie.
who don't fall within that category.
Cela étant,
Having said that,
je pense qu'on peut se rapprocher de
I
la
think
Chambre 8
that we could go close to the interpretation of Chamber 8
pour leur proposer le système suivant,
to propose the following system.
c'est-à-dire donner à VPRS
To give
la liste de nos
VPRS
témoins
the list of our witnesses
afin pour VPRS de vérifier
such that VPRS can verify
si parmi ces témoins,
whether among those
d'aucuns
victims,
ont eu des demandes
among
qui ont
those
été
witnesses,
rejetées
whether there were applications that were rejected,
aux fins de réparation ou
applications for
ont
reparations,
obtenu
or
quelque chose dans le
whether they
processus de
obtained
réparation
something within the reparations process,
ou sont censés en obtenir quelque chose dans les temps qui viennent.
or will be obtaining something in the coming time.
Je crois que c'est une manière de
I
clarifier
think
les
that's one way
choses
of clarifying matters,
et de partir avec une table bien claire et
and to
bien
have a
renseignée.
very clear table which shows this precisely.
Maintenant, pour la question de la
Now, where it concerns the
contamination,
issue of contamination,
c'est évidemment quelque chose que la défense
that's
peut
obviously something that the defense
faire valoir en contre-interrogatoire, mais là,
going
on
to
est
bring
dans
up
le
in
curatif et pas dans le
cross-examination,
préventif.
but that's talking about healing rather than preventing. So
Donc, effectivement,
here, what we're
ça
looking
dépend pas
at,
de l'accusation,
well, it's
ce
not
n'est pas
up to the
lié aux activités du
prosecution.
trust fund,
We're not linked to the activities of the trust fund,
mais si des mesures pouvaient être
but
prises
if
pour faire en
measures
sorte
are
que,
taken to ensure
il n'y ait pas
that
telle
there
contamination,
is
ça
no
serait
such
évidemment
contamination, obviously
l'intérêt de toutes
that
les
would
parties
be
de cette
in the
salle
interest of all parties in the courtroom, and indeed with a view to finding the truth.
Mais là, effectivement, s'il incombe
But
à la
there,
défense
of course,
de
it is incumbent
saisir
upon the defence
la chambre 8
to
en ce
seize
sens,
Chamber
quitte à
8
ce qu'on fasse
in
aussi des
this regard,
observations, à cette occasion.
or to make observations thereon.
Je vous remercie, Madame la Juge.
Thank you, Your Honour.
Merci pour ça.
Thank you.
The representatives of the victims, would you wish to make any comments on this issue?
Oui, Madame la Présidente. Merci
Yes, Your
beaucoup.
Honour. Thank you.
Pour les inquiétudes
Where it
soulevées
concerns
par,
the
la
concerns
défense,
that were raised by the defence,
c'est vraiment prématuré.
it's very premature
Prélever
at this
un certain nombre
stage
de points.
to raise a certain number of points at this stage of the proceedings.
Je préfère signaler que
I would prefer to point out
il y a une jurisprudence de
that
la
there
Chambre
is
d'appel
jurisprudence from the appeals chamber
très bien
which
le
does
processus Almadi
guide the Almadi process
s'agissant de la
where it concerns confidentiality
des éléments produits
and
et
evidence
l'accès à ces
and
éléments.
access to that evidence.
J'aimerais bien
I
pas
would
m'étendre là-dessus.
I do not wish to spend too much time on that. The jurisprudence is accessible.
S'agissant
Now, where it
des points qui
concerns
sont
the
relevés
points raised
au stade des réparations,
at the reparations stage,
je préfère signaler que
I would prefer to
le
point out
processus de réparation
that the
est en
reparations
cours
process is underway,
et que pour le moment, il y a une
and for the
procédure
moment, there is a
d'identification
procedure underway of identifying
des demandes de réparation, des consolidations de ces demandes
applicants,
et que
and
aucune réparation
no
individuelle
individual reparations have been allocated
parler
as
du
yet.
rejet de la
So
demande de
if we talk about
réparation
rejecting
à
reparations for
réparation
victims on an individual basis at this stage of the proceedings
prêtera à confusion.
would lead to confusion.
Je serai prudent de
I
ne
would
pas
be prudent
avancer
and not
les solutions en termes de
put
rejet,
forward the solution as a
plutôt
rejection,
attendre
but rather
et, la
wait
réparation prenne fin
for
pour le
reparations to come to an end in the Almadi
qu'il y ait des victimes
trial,
présentes
and so
au
that
stade
the
de cette procédure.
witnesses who are present there can speak about
J'aimerais
that.
bien tirer un petit trait
I would also like to
le fait que
mention the
la
fact
défense
that the
souligne
defence
la lecture très bien faite du
has
plan de réparation
raised
surgé qui note
elements of the redacted
la
plan
présence
which
de
notes
l'ONG
the presence of the NGOs,
qui est prévue pour
which is envisaged
forme de réparation
for a form of collective reparations, but with an individual connotation. That hasn't taken place yet, and the fund hasn't yet spoken on that issue. It would once again be premature to speak about it in terms of a solution, whereas the process itself is not yet underway. And what is true is that the fund will proceed with this form of reparations for this type of victims. But we're not at that stage yet. I'd like to finish by making a clarification that the organs in the Al-Mahdi proceedings are ensuring that contagion or contamination cannot happen with regards to the Al-Hassan proceedings. Thank you. Yes, thank you, Madam, for giving me the floor. Your Honour, I just wanted to add to the intervention of my colleague by going down a particular avenue. I certainly understand the concerns expressed by the defence, which are very relevant, where it concerns overlap of the cases and the charges. Al-Mahdi and Al-Hassan, they're not exactly the same, as has already been mentioned by the prosecution, but there is grounds to raise a question about certain aspects when we're raising issues of protocols on confidentiality, taking into account that there are victims in Al-Mahdi who are also participating in Al-Hassan, even under other charges than the first case. And where it concerns Al-Mahdi, currently there are several actors that are intervening. They are in contact with victims. There's VPRS, VWU, the fund, the Trust Fund for Victims, and at this stage, guaranteeing confidentiality and the mechanism of contact with these victims does risk being complicated and difficult. And I also wanted to make a suggestion in this regard. Outside of this courtroom, you have different actors who are concerned. If they could come together and if they could try and find a path to sort out where these problems can be resolved. We can't penalize the Al-Mahdi case, suspending it, while we await Al-Hassan to make progress at a certain level to see if it's possible to let an Al-Mahdi case continue. And so what I would suggest is, outside of this courtroom, is if we could have working meetings with the defence, obviously, to try and really find exactly where the problems are with VPRS, with the Trust Fund, with BWU, and the legal representatives of victims, and at the end of these discussions to seize Chamber 8 to come back before your chamber in order to present exactly what the problems are or what risks there might be for victims participating in Al-Mahdi and Al-Hassan, or if there would be any type of obstacle with regards to the work of either the prosecution, the defence, or the legal representatives of victims. Thank you.
Merci beaucoup.
Thank you very much.
Mr. Besson, does the registry have any comments at this stage? This is obviously a preliminary discussion of this issue.
Oui, très brièvement.
Well, yes, very briefly, Your Honour. So, indeed, we have before us 4 different parameters that have to be taken into account, and it is clear that there are similarities between the 2 cases. There are therefore the applicants for participation as well as for reparations now in the Al-Mahdi case who could be the same. So indeed, it's relatively important, at least when we think about the third parameter. And what's that? That is the dual status that we have. There's a need for clarity on the second point, which is indeed to be able to identify who has what role. Now, there's a fourth parameter which hasn't been mentioned here. Everybody speaks about at this stage in the proceedings, but it's extremely important, however, that we are clear with regards to the statute. At the time when you have a dual status appears when you have somebody physically embodying that dual status by appearing in the courtroom. Perhaps that'll happen in October, November, or in 2021, at the time that reparations have largely progressed. And there will indeed be potentially a problem that some have called contamination here. Now, the fund, normally, if there hadn't been the Almadi case, it would have potentially had the second mandate that it would have exercised, and when that is done, the trust fund would not have would not want to know what the status of the victims is where they intervene or take action. And the case is, when the second mandate isn't being exercised in the Al Hassan case, there's reparations. In the Almadi case, where when we speak about collective or individual reparations, the names of persons are known. Now, the names of people who come to the courtroom, if indeed they are receiving a form of reparations of any type of whatsoever, that will be known before these people come to testify. So it will be necessary, indeed, I think, to be able to identify what exactly the status of this victim is, who could also be a witness, who could also be in both cases, and I think that it's important to be able to identify them. Not to transmit it to the fund, because they don't want to know that, but to be able to manage them in terms of the credibility of the witness in the case. The registry is a neutral organ. We have a lot of information, both from the VPU, which calls the witnesses, and with the prosecutor, but also the defense later, and the legal representative of victims as well. They can also call witnesses. So there's information there. The Unit for the Participation and Reparations, VPRS, also has this type of information, but we protect this information. We make sure there's no exchange of information, and when we don't have a legal key in order to do so. Now, there is an additional argument here, which is namely that the decision that is taken in the Almadi case, well, these are decisions that are also taken at legal level by a chamber, by judges, and as such it is essential for us also to be able to turn towards the chamber responsible for reparations in order to have the authorization or leave to have access to certain information. And indeed, we can collect this type of information, we can communicate it, transmit it to the chamber, to yourself, but indeed we have to see when these reparations will eventually take place, and I think that they could take place at the time of testimony. And I perfectly understand that it is essential within the framework of a fair trial and an expeditious trial that we have clarity on this specific information. Thank you.
Merci pour ça.
Thank you for that, Mr. Dubuisson.
Well, again, I thank the defense for raising the issue. I believe we've had a full discussion from the different perspectives. Obviously, this is an example of the complicated structure of the Rome Statute and the fact that we have various players in place, including the Trust Fund for Victims, which is an independent body. and in the context of two cases. So it is a complex situation. I believe that as all of the interventions have identified, I think at this stage what is very important is that there is liaison with amongst the parties and also with VPRS and with the Trust Fund for Victims to try and at least bring some clarity to where the particular intersection points might be, as suggested as well, to try and identify very clearly where we might have very specific issues with witnesses or dual status individuals. So I would encourage all of the parties, participants, and the other bodies to carry out those kinds of consultations to try and advance this issue, and then we can come back to the issue in front of the chamber once we have more clarity. And the idea of suggested by the prosecution, I think, is a good one, of trying to identify at this stage, using the information that is available, where there may be specific issues already. So I would simply encourage that discussion to take place. I think this is an important issue to keep mindful of. I would also note it's not the first time that we've had an intersection of cases. We had an instance with Lubanga and Ganda. So we do have some precedent to look at how things were managed, as well as the appeals chamber's decision can be looked at and examined too for guidance. So with all of those parameters in place, I trust that all of the parties and participants can work on advancing this issue. And again, thank you for bringing it to the chamber's attention. Certainly I will discuss it with my colleagues as well, so that we are well aware of these issues. We can move then, I believe, to the next issue, which is once again a defense issue, and that is the logistical issues related to defense investigations. I believe this may be related to defense filing on the 31st of January and a decision I issued on the 3rd of February, both of which were filed in public redacted form from last Friday. So, Ms. Taylor.
Thank you very much, Your Honour. I would wish to preface my submissions by the point that although I'll primarily be focusing on the role of the defence in conducting investigations, the concerns that I'm raising are equally applicable to the legal representatives for victims, and for this reason they may wish to make submissions as well on these points. It is not disputed for the purposes of this case that Mr. Hassan is indigent. He has a right to legal assistance. And under Article 83, this encompasses all costs that are necessary and reasonable for the conduct of an effective defence. And that encompasses effective investigations. Now, we are obviously not staff, but the particular administrative label that's put on our heads shouldn't impact on our ability to conduct safe and secure investigations. And this is a principle that's been recognised by the Assembly of State Parties, by the Bureau on Cooperation, in its report, which is in our Table of Authorities. And paragraph 1 or 2 of that report says, there is no fair trial without providing the defence with adequate facilities to prepare its case. In particular, as concerns the investigation and collection of evidence. And at paragraph 104, the Bureau went on to state, in this respect, Defence Counsel and their teams receive the same security, logistical, and administrative assistance as court staff. Such assistance is primarily provided by the court's field officers, but also by the United Nations officers and states. The same, not almost the same or roughly the same, but this report commits the court to providing the defence with the same security. This principle, that we have the right to the same security, logistical and administrative assistance as court staff, is of crucial importance to the right to a fair trial and the specific right to call witnesses under the same conditions as the prosecution. Our lives and those of the persons we interact with are not worth less just because we're on the other side of the courtroom. And if the court has a duty of care when it approves prosecution missions, then it has the same duty as concerns defense missions, which are approved and funded under the court's legal aid scheme. And this was something that the Registry explicitly confirmed at a legal aid consultation meeting in 2018. Again, this is in our table of authorities. And in response to concerns raised by the head of the Office of Public Counsel for the Victims concerning the difficulties in obtaining insurance, particularly when travelling to high-risk areas, the Director of Judicial Services stated, "Now, when it comes to medical evacuation, emergencies and what have you, the court's Medivac system would address those issues. The courts, not the defence." It is also notable that in the 2014 guidelines on intermediaries, the court specified in Principle 5 that the court has a duty to prevent or manage security risks to intermediaries when those risks result from the intermediary's interaction with the court and the fulfillment of the intermediary's functions on behalf of the court. Now, if that duty extends to intermediaries in the largest sense of the word, then surely it extends, at the very least, to the defence, who are appointed and travel with the authorisation of the court. But these principles, these commitments, in our view, have not been applied in this particular case. We have not been afforded the same logistical, administrative, and security assistance that the court committed to. These promises that we could benefit from the court's Medivac system have been resiled from at the last minute. Now, we have stated quite clearly for the record that in order to fulfill our duty to Mr. Hassan and to investigate this case effectively, we need to travel to certain areas, whether it be to meet witnesses or to do a site visit. And that includes Timbuktu. For this reason, we asked the Registry on the 22nd of August last year to conduct a security and feasibility assessment. We submitted a detailed security and mission plan at the beginning of December. And on 3rd of December, we asked for clarification as to what would happen if we needed to be evacuated or if a security issue arose. And that day, for the very first time, the Registry posted on the intranet its stance that we had to try and obtain personal insurance for this. Insurance, not just for our lives in The Hague, but insurance from evacuation from a high security area. This isn't a position that had appeared in previous legal texts, and it flies in the face of the commitments that I just mentioned, that we would benefit from the same services as a prosecution, including from UN field officers. This circular had no information or details as concerns the type of insurance providers who would provide us with this very specific form of insurance. Although we had heard from the ICCBA that this was an issue that they were liaising with the Registry on. We therefore carried on with our planning. This included a meeting at the end of December where we were told that in order to board a UN plane, we would have to sign a waiver of liability. And what this waiver would mean that if the plane crashed through an accident or negligence, we would have no recourse against the United Nations. Now, if you're an ICC staff member, a contractor, and a consultant, a prosecution intermediary, or an interpreter, that's fine, because the court indemnifies you for any service-related death, injury, or damage that occurs on official mission. But so far, the Registry has refused to close the gap and confirmed that we would have an equivalent form of protection if we sign that waiver and it turns out that our personal insurance doesn't cover us. after this shocking reveal, we were also told that if the United Nations decides to charge the court for any of the services that it provides to an ICC mission, the registry might turn around and bill us in our personal capacity for these services, not from the legal aid budget, but from our own pockets, as if we were traveling to Mali on a holiday. Now, this is a completely arbitrary and unacceptable form of discrimination. There was no written policy to this effect that we can be personally liable for these costs. This notion was pulled out of thin air. And I can't see any legal basis for discriminating between the prosecution and the defense, given that the agreement between the ICC and MINISMA on this point is exactly the same as the agreement that's used with the prosecution. It's exactly the same as the agreement that's been used between the ICC and other UN field officers. And I've consulted with other defense teams that travel to Congo and the CAR, and no other defense team has ever been told that they would be personally liable for such costs. We are the first and only team that have been told that we are personally liable for costs that the UN might pass on to the ICC pursuant to an agreement between the UN and the ICC. Now, we can't be placed in a situation where we have no clarity as concerns what would happen if we go on mission. We can't cross our fingers and hope that nothing happens to us and that we won't receive a big fat bill in our email. And we would submit that this absurd situation is not consistent with the registry's duty under Rule 20 of the rules to provide all necessary and reasonable assistance so we can perform our investigations in an effective and independent manner. If the registry approves a mission under the legal aid scheme, then it's the legal aid scheme, not our personal pockets, that should fund the costs and expenses arising from the approved mission. And if the court asks us to sign a waiver of liability as a necessary component of that mission, then the court has a corollary obligation to ensure that we have some form of protection as concerns consequences that could stem from signing this waiver of liability. And I would like to underscore that what we're asking for, it's not exceptional, it's not unique. It's a right that the ICC has extended to non-staff, including contractors and consultants. It's a right that exists under basic principles of law that apply to international governmental organizations. And in terms of the basic principle underlining this right, I would like to refer to a 2017 interim report of a UN high-level working group on duty of care. And again, that's in our table of authorities. And it says that this basic duty of care for non-staff falls or derives from general principles of the law of responsibility, whether it be tort law under the common law system, the law of responsibility under the civil law system. It also derives from the jurisprudence of the UN Administrative Tribunal, and it falls and is considered to be a general principle of law that would apply to all UN personnel in a direct contractual relationship with the UN. If it's a general principle of law, then it's equally applicable to the ICC as an international organization. A 2019 report from the same committee then identified 5 pillars concerning the duty of care to non-staff when they travel on official mission. And again, I'd like to emphasize this isn't applying to The Hague, it only applies when we're traveling on official mission. And these pillars can be summarized into 3 essential duties. Pre-deployment, that non-staff have access to appropriate medical services and insurance coverage. During deployment, that we're included in any evacuation and security scheme. And post-deployment, that there's a follow-up mechanism and compensation in case of lasting damage or injury. This duty to ensure that we're covered by an appropriate form of protection, it isn't discharged by sending us links to insurance companies without any form of effective verification as to whether they would provide us with effective protection in our unique circumstances. And it isn't that we haven't tried. We contacted the providers only to be given the runaround and to receive the eventual answers that we've appended in today's filing, saying, sorry, we can't help you. It's also a matter of basic common sense that an insurer isn't going to reimburse us for unknown and unspecified costs that the registry may or may not pass on to us in unknown circumstances based on unknown criteria. Even the high-risk travel company wouldn't cover travel to a country which is experiencing political unrest before the date of travel. It would also only reimburse costs if we relied upon their pre-approved providers. That is not the United Nations. So it wouldn't cover any expenses incurred by the UN. If you look through the exclusions that we've attached to today's filings, it wouldn't cover a range of circumstances, including if Mali were to accuse us of violating national law for associating with alleged terrorists. So we're very much left in the limbo there. And importantly, it wouldn't cover our resource person if he were to travel within Mali or use a UN plane. We submit that risk management means avoiding preempting risks, not hoping it'll be all right. Our missions to high-risk areas are stressful enough without having to engage in litigation concerning basic rights mid-deployment. The right to a fair and speedy trial also means we need to have an immediate solution for this issue. We appreciate the registry's efforts in this regard, but we can't wait for working groups to hash out a solution. Given that the court publicly committed to providing us the same security, logistical, and administrative facilities as the prosecution, we should have the right to benefit from that assistance now and to have that applied to this case. So we're willing to do all we can to try to continue to identify an insurer. But we need to know that we have a legal safety net if and when there's holes or cracks in these policies. And we are left out there with no effective protection but this court. We would like to know in advance that the court will be there to provide us that protection so that we can go ahead and conduct these missions in a fair, effective, and secure manner. Thank you.
Thank you, Ms. Taylor. I'm going to, at this point, give the floor to the registry, given the nature of your comments, for any comments you might wish to make, Mr. Dubisson. I do so noting that there is already the decision which was taken by the single judge on the matter. You can bear that in mind, but in light of the representations, I assume you would like to make some comments at this stage.
Yes, thank you, Madam President. I think I will take about 10 minutes. To begin with, I would like to point out that us, the registrar, we never allow a person, and we will never allow any person anywhere without assistance. We have even taken risks to possibly assist people. So the registrar has a purpose to provide assistance to all defense counsel under Rule 20, Article 20 of the Rules of Procedure and Evidence. So it is important for us to be very precise on the scope of application of certain rules that may be confusing and give the impression that we are not acting correctly. So given the framework of a mission, everything was in place for the recent mission of the Council. The obstacle came about because the defense refused to sign a waiver which applies to everyone benefiting from the services of the UN without distinction, whether they are court employers or not. For more than 2 months, the registrar was communicating with the UN services, and I would like to thank them for all their assistance, specifically, not only on the ground or in the field, but in New York, because there's a lot of diplomatic activities that have to go on to arrange these situation. However, the registrar does not control the conditions and requirements of the UN, particularly the signing of a waiver under certain circumstances. The registrar fulfilled its commitments for the mission, but which was cancelled by the defense because they did not want to comply with the requirements of the UN. Under Article 20 of the Rules of Procedure and Evidence, the registrar facilitates missions for all defense teams and LRVs for the same destinations. I would like to point out that during the period that we are talking about, the legal representative of the victim was in place and followed all the conditions that Ms. Taylor did not want to follow. I would like to point that out. The trust fund for victims is also there. Our experts and the experts of the fund also went there under the same circumstances. Regarding the particular problem of insurance for non-medical reasons, in the case of evacuation, for example, the defense seems to use this aspect of the organization of the mission to state that the court has the same duty of care towards counsel as well as its employees, particularly those in the OTP. However, there is no link. It is not a discussion on the duty of care of the court, but the scope of application of Article 20 of the RPE and to what extent the registry can facilitate the work of the defense. However, irrespective of the nature of the evacuation, whether it is medical or security reasons, all defense staff, apart from local individuals, are evacuated by the UN as long as they fulfill the conditions. And the court has agreed to benefit from this agreement. That is why the registry provides assistance to the defense teams. Now, there is a financial aspect that the UN insists on. When they provide services, they may be charged to the court automatically or not. So the court pays the invoice for the services, and then they turn to the council that would have engaged in an insurance policy before the mission. So there is also a sickness and funerals in case of death. This is a different case altogether, which is different from the cost of evacuation. We have to be well aware of what we are talking about. The court wants to benefit from the scheme of the court employees, especially OTP employees, using the principle of equality of arms. For employers or employees who are contractual employees of the court, consultants and individual consultants, they are covered by a specific program and they receive compensation for services for injuries and illness during services. When a counsel is on the roster of the court list, it is obvious that the system is different, because this is different from the people who are outside of the court, who have the obligation to have their own insurance. Counsel are much aware of their obligations, their fees, and the professional charges. So we advise the counsel to pay those insurances, and I'm talking here of amounts that are not enormous. As the defense states, the cost of such insurance is to be borne by the counsel. In case of illness, death, and so on, there are discussions relating to what should be done, but this is outside of the scope of the session of today. The idea is to change the legal aid policy, as the defense seems to want to propose, or to change the status of the counsel so as to benefit from certain advantages. These discussions are ongoing. So the agreement will come. That is why the registry is envisaging all possible options, and more realistically is thinking about cooperating with the bar, that is the ICCB, to see whether a collective insurance policy with certain partners might be possible. The contractual relationship is with their clients through the representation mandate, and not with the court. The court is not the client of the counsel. The court simply remunerates counsel because of the indigence of the accused. It is not because of that that the court would automatically have a duty of care. So there is a difference between indigent clients and non-indigent clients. That is what that supposes. But the court should have the same obligations with all counsel, and that is specified under Article 20, and should not be confused with other aspects relating to the evacuation of counsel in other cases. Thank you.
Thank you. Merci, Monsieur Dubuisson.
Thank you, Mr. Dubuisson.
I believe the positions have been reflected now on the record on this issue. The position of the Chamber, as is reflected in the decision of the single judge, which I issued on the 3rd of February, the question that is being discussed, on which there have been representations, is a matter of the application of the policy of the registrar in relation to legal aid. The Chamber does not have general oversight over the mandate of the registry. What the Chamber has is a review power for specific decisions, and we have reiterated that position, that if there is a specific decision which merits review by the Chamber within the statutory framework, we're prepared obviously to entertain that. I appreciate the concerns that you have raised, Ms. Taylor, but the matter needs to be resolved as between yourself and the registry through continued consultations. I would urge you to continue to discuss possible solutions for this matter. As Mr. Besson has indicated, there are ongoing broader discussions as well, but none of these matters are matters in which the Chamber is going to intervene. So I leave the matter at that point. I don't believe there's a need for any other interventions on the issue unless someone felt very strongly about it, as indicated. The points are made on the record, but the Chamber's position remains that it is not a matter for the Chamber at this stage. Ms. Taylor.
Thank you very much, Your Honour. I think it needs to be stated very clearly for the record that we will not conduct investigations unless we have this security. And yes, I refused to sign that waiver. And I can't see any legal principle obligation for me to make my team conduct investigations, to accept situations where they do not have protection. The fact that other entities have done so is neither here nor there, particularly when the entities that you referred to are, for the most part, covered by the court. So it might be that this is an issue for the registry to address, but the issue of Mr. Alassane right to speedy investigations is before this Chamber. And we cannot conduct investigations without protection. That's absolute. As counsel, I will not put my team members in that situation. And I cannot see any legal obligation for me to do so when this is an issue that can be solved very easily. The court extends its insurance program to witnesses when they travel. There are easy solutions. We should not have to wait for a working group to come up with a solution when this impacts directly on this case. And Madam Prue and I are both in the ICCPA. We can assure you that we can't see a solution from the ICCPA coming out overnight. So these discussions that are happening, we're not aware of them. And certainly, they will not be crystallizing in time to assist this case. So what we're asking for, at the very least, is an interim solution. We have a position from the registrar. This issue is ripe for judicial determination. And we need an interim solution which will allow us to conduct investigations now. Not in August, not when the registry submits its new legal aid policy, which has been on the boiler for 3 years now. This is something that we need to address now. And it is a basic principle that, as I said, we will do all we can to find insurance. But if there's cracks in those insurance, if we are evacuated to a country and told we need to have surgery and our insurance won't cover it, then we do need assistance. And we need to know before getting on that plane that that assistance will be forthcoming, not afterwards. Thank you very much.
Thank you, Ms. Taylor. Let me note that to date, this issue has been raised before the Chamber, framed on the basis of the application of the legal aid policy, essentially, and has been adjudicated on that basis. If you wish to bring an application that is framed on the basis of the Chamber's obligations under Article 67, if it is a fair trial issue you wish to raise, then you are free to bring a motion to that effect. that would be inter partes and would be litigated with input from all parties, including and participants, and the Chamber can litigate it and consider it and adjudicate upon it on that basis. But we will not adjudicate upon it on the basis in which it's been framed to date. If it is reaching a point of a fair trial issue, then of course that is your right to bring that before the Chamber, but you need to do so in a manner that allows for input from the parties, the prosecution, the legal representatives of victims, obviously the registry, and the matter can be brought before the Chamber in that manner. But we need to move it forward in that context, and if it is affecting investigations, it needs to be dealt with urgently, but in that format. So with that, I will conclude that particular agenda item. I would think that at this juncture, it might be a good time. We're 5 minutes short of the planned 11 o'clock, but I think given the topics which we've been discussing and the temperature in the room, perhaps we can at this point take an adjournment for a half an hour and come back at 11:25 and proceed with the remainder of the agenda items. So we are adjourned till 11:25. Thank you.
All rise, we will leave it.